persons having anything to do before the Honorable Beverly Canoni, Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Thank you. Please be seated. Court is in session.
22117, the Commonwealth versus Karen Reed. Counsel, could you come to sidebar, please?
Good morning, Your Honor.
Good morning.
Good morning, Judge.
You have to stop being late. Really.
I just wanted to put very briefly on the record with regard to Ms. Kuhn. We want to interpose an objection just for the record in terms of her testifying before the foundation has been properly laid. I sort of expected it. I knew that she was going to be taken out of order. Mr. Lally let us know that, but I expected...
Because of a mystery reason? Because this part of the transcript is redacted? Is that what it is?
Yes. I have no problem with that whatsoever. I just want to make sure that I didn't waive any objection if the later foundation for her testimony is not established. I think it will be.
If it's not established, move to strike it.
Okay? That's what I wanted to make sure of. That's all. Thank you.
Okay.
While we are here, one more thing, Your Honor.
Sure. Of course.
Based on the court's order yesterday, the Commonwealth did review the professional rules of code of conduct.
Okay.
The Commonwealth did not find any rule that pertained to the situation or the issue that defense counsel raised. The closest thing would have been professional rule of conduct, 3.4a, discussing an attorney's duty not to obstruct evidence. That's not what the Commonwealth did nor intended to do, and there's no cases citing that rule for any proposition or supposed issue raised by the defense. However, given the court's broad discretion, the Commonwealth, myself, and AD Lally will abide by the court's order as it likely falls within the judge's broad discretion pursuant to Criminal Procedure Rule 21 and sequestration. So myself and AD Lally will abide by the court order as I presume defense counsel will as well.
Okay. Unlike all of you, I have never been a prosecutor. All right. Are you still moving for that, Mr.?
Yes, Your Honor, we are. Anybody from the Commonwealth's team, their investigators, their victim advocates, the trial team themselves. Nobody from the Commonwealth, just like nobody from the defense, their victim advocates, the trial team themselves. Nobody from the Commonwealth, just like nobody from the defense, should be engaging a witness who is currently under oath during the breaks, overnight and things of that nature. It's just not done.
I think investigators is a little too broad. Police not allowed to talk to witnesses.
Not while they are on the stand, not while they are under oath.
What do you say?
There is no rule that suggests that. If that's the court's order, the Commonwealth would abide by it. However, I feel as if victim witness advocates need to be able to speak to the witnesses. As it came up in this case, our witness was confronted about a conversation they had with a member of the Commonwealth, and their answer was they asked me if I wanted any water. So I think to effectively, move the trial forward, advocates or witness people need to be able to ask people, do they know where the bathroom is, or you're going to be next up in 5 minutes. Just normal ability to facilitate the time management of the trial.
To be clear, that's not what I'm objecting to. I'm objecting to any interviews or discussion of the substance of their testimony. Asking where the bathroom is. What time do you need to be here? Can I have some water? I have no problem with that.
How long your testimony is going to be?
Correct. You're going to be another hour. I have no problem with that. I just don't think it's appropriate to talk to them about, I'm going to ask you these questions. I expect Mr. Jackson...
Yes, I don't think that's proper either. I may be wrong. But I do know sometimes things come up during trial that a police officer has to go out and find a witness or approach a witness or something based on something that's been said. So I don't want to tie the strings of law enforcement. I was concerned you raised it regarding the lawyer, Mr. Lally, and that's what I addressed.
Right.
So, Mr. Lally, you're not to flag the witnesses what you're going to examine them on, or do redirect on, or any other substance of what you're going to do.
Understood, Your Honor. Just so the record is clear, that is not what happened in this particular case. I went to tell the witness, this one being Mr. Albert, how much I anticipated he would be left on the stand. He asked me a question as far as, are you going to cover this in your direct? And I said yes. There was no substantive conversation about, I'm going to ask you this, or Mr. Jackson may ask you that, or anything along the lines. But Whatever the court's ruling is, obviously, the Commonwealth will abide by whatever the court tells us to do.
My understanding has always been when a witness is on the stand, you can't discuss anything of any substance with that witness.
I understand.
And that's what I always thought, and that's what I believe. We will leave it at that.
Thank you.
Thank you.
We can bring the jurors in.
Jurors, please.
Next witness, please, Mr. Lally.
Yes, Your Honor. The Commonwealth will call Ms. Terry Kuhn to the stand.
While she's coming in, can I see counsel just about this witness for a second, please? Mr. Jackson.
So I know sometimes I do tell jurors that the witness is out of order. Is there any reason to fear or anything?
I think I would prefer it just because I think I would.
Is there an objection to it?
No.
And then I can just say sometimes schedules make it such that we have to have witnesses testify out of order. All right. Thank you.
Thank you, Your Honor.
Next witness testifies. I just want to tell you that sometimes we call witnesses out of order. Sometimes witnesses have to be called in a certain time frame because of their schedules or some other instance, and the lawyers were kind enough to work this out among themselves, so we appreciate it. All right.
What about the next day or the rest of January or any day in February of 2022? Did the state police come to interview you about the information that you had as the driver of that vehicle?
No.
In fact, isn't it true that no investigator from the state police or the district attorney's office interviewed you anytime during the entire year of 2022?
Correct.
And that the first time you spoke to any official, it was not from the district attorney's office and not from the defense in this case, correct?
Objection.
Sustained. You can word this differently, Mr. Yannetti.
Okay. The first time you gave a statement to anyone, it was not Mr. Lally or the state police, and it was not the defense in this case, correct?
Correct.
And that was on May 16th of 2023?
Which time would that be?
First time you gave a statement, sir. May 16th of 2023, does that sound correct?
Around that time it would be.
Okay, and you know today is May 15th of 2024, right?
Yeah.
So just about a year ago was the first time that you gave any statement about your memory of what occurred on January 29th of 2022, correct?
Correct.
And you would agree with me that your memory of what occurred on January 29th was the freshest when you got up that day, later that morning, correct?
The next morning after the 29th?
Yes.
Correct.
Right. And you'd agree with me that, your memory would have remained fresh for a period of time, correct?
Correct.
And you would agree with me that over time, your memory becomes less fresh, right?
I would agree.
And it's not just you, it's everybody, correct?
Correct.
Objection.
Let's move on from this.
Sure. And you were first asked about your memory about what was clearly over a year after January 29th, I suppose February, March, April, maybe about 16 months after the events that you were asked to describe, right?
Correct.
And then it was only after you talked to someone else, again, not the prosecution or the defense.
Objection, Your Honor.
Mr. Yannetti, why don't I see it sidebar, just so we don't keep getting interrupted there.
What is the objection?
I mean, I think Mr. Yannetti has danced around it, but at this point, I don't know. I think the point has been made. So asking any more questions about this particular topic, I think is going to end up eliciting a response similar to Mr. Nagel's response. We are just going to get into an area that's prohibited.
Can you say proceeding? I'm just concerned that,
I know.
just so the record is clear, I do not say for a second that Mr. Jackson intended to have that result.
No, I did not mean that otherwise.
I know you didn't. I just wanted to.
No, I appreciate that, Your Honor. So I think we are past. I'm not talking about the feds, not because now I'm asking about the state police. An interim proceeding. It actually was not testimony, it was an interview.
Right.
So I'm trying to.
It actually was testimony. He testified in the federal grand jury.
I didn't think you were going after this testimony. I thought you.
That's right.
So I didn't understand what you're doing. I thought you were talking about a report.
It was a report. All I'm after right now is that he talked to the state police in September. So I'm not asking him about anything to do with any other agency, just playing off of the first time they talked to him was in September. So I don't think there is a danger of, or anything else at this point. I'm leading him, and I'm going to say it was the state police in September. I think he will agree with that.
Okay. I just ask you for caution. I didn't understand where you were going. I thought it was a report, but I knew he testified at the federal grand jury.
Right.
And if you're asking a report, and he's talking about federal grand jury.
Of course.
So I was just going to ask you, the first time that you were approached by the state police regarding this case was September 2nd of 2023, correct?
Around that time, correct, yeah.
Right. And that would have been 5 months after the first time you were approached, and it would have been about 21 months after January 29th of 2022?
Correct.
All right.
And so first thing I'm going to show you a 2-page document. Just ask you to take a look at it and we'll go.
Okay.
And do you recognize that, man?
Yes.
And what do you recognize that?
This is from my phone, my text messages.
And the second page, what is that?
Colin's contact information.
Are those screenshots that you took from your phone and provided to the troopers in August of 2023?
Mm-hmm. Yes. Yes. Yes.
Mayor, Coach, you know.
Yes.
Commonwealth to seek to introduce the event as.
Objection, I'd ask you to.
Okay, come on up and bring that.
Your Honor, I'm objecting on multiple grounds. One is that this is rank hearsay. It's being offered for the truth of the matter asserted. Secondly, and equally important, is that these screenshots are unreliable. We don't know that they are what they purport to be. In other words, there are times listed there, but again, being offered for the truth of the matter asserted, which by an iPhone can be changed very easily by going into settings. So we don't have a forensic extraction of the phone. The police did not ask to actually take her phone and confirm that those times are actually accurate. They chose not to do that. And given that her phone is gone now, they robbed us of any ability to challenge those times through forensic methods. So I believe these are inadmissible in the form that they are in. If the court is inclined to overrule my objection, I would ask for a voir dire to be done before these are admitted.
Okay, what do you say, Mr. Lally?
Your Honor, what I say is that the witness on the stand is a participant in the conversations and can authenticate those conversations under Purdy. Secondly, I would say as far as any questions that counsel has to them, go to the weight and not the admissibility.
How long of a voir dire do you need?
10, 15 minutes.
All right, I'll give you a short voir dire.
Your Honor, if I may, just for the sake of not coming back up,
Yes?
I also intend to introduce those two. They are also screenshots that she took for photographs of Colin Albert from February 11th. Essentially, what these are 2 separate photographs from the defense that show the Alberts' home. She was present during this event, so she can authenticate that's what Colin Albert looked like on February.
Who is the one?
That's Nicole Albert.
All right. So we will have a voir dire on it.
Step out for just a few minutes.
Court, all rise, please.
I could excuse for 1 second just to pick up something that's up right in the hallway.
Okay.
If you could just briefly explain to the witness what's occurring.
Yes, I just need Mr. Yannetti back.
Sorry.
Okay. So, thank you. And the next two, if they would be marked separately, please. If you need to do it, go ahead. I'm just trying to.
I want to accommodate the court. With regard to the messages that are in a given thread, right? We've talked about the fact that you are aware that you can reply to them, an individual message, forward or delete one, correct?
Correct.
You're also aware that it is possible to change the timestamp on any individual message, correct?
No, I'm not aware of that.
You go to settings and you go to general and you go to date and time. First of all, you can change the time zone of the message. Do you have your iPhone with you right now?
Not on me.
Not on you? And in addition to being able to change the time zone, you actually can change the hour and minute to whatever you want it to be. Were you aware of that?
No.
With regard to photos on your phone, you are aware that you can change the date and time of any photo in your photo app, correct?
Nope.
There is a little, when you go to your iPhone, there's a little I for information. And all you need to do is, I think it's for info or information. All you need to do is click on that, and you get a pop-up from the bottom that gives you the choice to alter the date and time. Did you know that?
No.
Next to that date and time is the word adjust, and that's all you have to click on. And you can change the time from 12:10 a.m., or you can change it from 12:40 a.m. to 12:10 a.m., or you can change it from 1:45 to 12:10 a.m. And it's that easy.
Yep. Now I know. I didn't know that. I didn't do that.
If I may have a moment.
Okay.
That's it for this one hearing.
Okay. So I'm going to allow this testimony in. Your argument goes to the weight of the evidence, not its admissibility. But I did, under Commonwealth versus Tracci, want to give you your voir dire. Okay? All right, so let's bring the jurors back in.
Yes, P-U-R-D-Y. Your Honor, before the jurors come back in, may I just retrieve the exhibits?
Yes, but I'd like to see counsel at sidebar while they're coming in.
So what you did during the voir dire, you can do with this witness. You just taught her something, I guess. So she said, now I know. So it's couched in terms of either pre-voir dire or post-voir dire. That's fine. If it's not, Mr. Lally is going to get leeway to then say that you questioned on those things.
Yes, I understand. Of course.
Okay. All right. Thank you.
Hunter, I think we should sit.
Of course, back in session. Please be seated.
Your Honor, I apologize profusely. I just need one more minute. I'm so sorry.
Your Honor, the only thing I was going to bring up, I understand the court's ruling. We object, but I accept it, obviously. But with regard to the photos, Your Honor, there is no need to have that date underneath the photo itself.
I didn't even notice that it was on there.
I am just asking that that be cropped off. If he wants the photo in, she can testify to the date. That's hearsay. That should not be part of the photo.
Do you care?
I don't care. But again, I mean, she was there for it and can testify to the date that the photo was taken.
Well, that's what I just said, as long as it's not on the exhibit itself.
Okay, so we'll remove it from the exhibit. Is it on a slide that you probably are going to put up on the screen?
It is, but I can advise Ms. Gilman she can put it on the screen, on the laptop, and enlarge it just for the photo, and then somehow.
Yes, as long as it's not visible to the jury, and we can redact it afterward.
Or one person at a time. Okay, she can do that. I'll give you a minute to let her do that.
Thank you, Your Honor.
And specifically on that date of January 28th and the 29th, when you arrived at the home on Fairview Road, you texted Colin that you were there?
Yes.
And after you texted him that, what, if anything, happened after that?
He responded saying okay, and then he came out to the car.
And Your Honor, if I may, with the court's permission, just publish the text communication to the jury on the screen?
Yes.
Now, what's up on the screen, Ms. McCabe, is that what you have before you as the exhibit?
Yes.
And looking at, there's sort of one side has text and one side has a blue bubble, is that correct?
Yes.
And if you know who is communicating with who as far as the sort of plain text outside of the bubble?
Colin and I? Is that what you're asking? Sorry.
What I'm asking is, who's the blue bubble?
Oh, sorry. I'm the blue bubble, and he is the gray, whitish bubble.
And from sort of the top of what's depicted on the screen, you read the text that you received and the time that you received.
Yes, 11:54, and then I responded at 11:55.
And what did Colin say at 11:54?
You can get me now if easier.
And what did you respond?
Okay, I am driving people home now.
And what did Colin respond to that, and what time did he respond?
He responded, word, get me after.
And if you want to could scroll down just a bit. And following the getting after, what if any response did you provide?
KK, okay, and here,
And here that you texted, what time was that read on the screenshot?
12:10 a.m.
And what if anything did Colin respond to your text?
He responded at the same time saying, okay.
Assuming you can take that. May I approach just to retrieve, Your Honor?
Yes.
Do you need that? Thank you. Okay, thank you.
So the next two pages, two separate pages, contain photographs, is that correct?
Yes.
And you recognize what's depicted in those photographs that I've just placed before you?
Yes.
And what do you recognize those to be?
It's Colin. Is that what you're asking?
Well, let me ask you more specifically.
Okay.
So, were these also screenshots that you provided to troopers of the state police in August of 2020?
Yes, I believe so.
What, in regard to those two photographs, do you know when and where those photographs were taken?
They were taken February 11th at the Alberts, Nicole and Brian's house.
Objection.
No, I'm going to let her testify when they were taken.
And so February 11th of what year, ma'am?
2022.
So a few weeks after January 28th, 29th, correct?
Yes.
And were you present at the Alberts house on the evening of February 11th when they were taken?
Yes.
And what was the purpose of yourself and or Colin or anybody being over the Alberts house on that day?
One of Nicole and Brian's sons were coming home from their Marines, so there was like a welcome home party with family and friends.
And that is your cousin Jack, is that correct?
Correct.
And as far as what's contained in those photographs, is that a fair and accurate portrayal as far as your memory of what Colin looked like on February 11th?
Correct.
And Your Honor, may I approach again?
Yes.
Almost seek to introduce in a minute the next two. Again, subject to our discussion.
Sure. Okay. Yes, those are clear.
If you recognize what's now up on the screen is what you have before you as Exhibit 82.
Yes.
And if you could just describe to the jury sort of what we're looking at in this photograph, who's depicted in this photograph?
Colin and my auntie Coco.
And your auntie Coco is also Nicole Albert, is
Yeah.
that correct?
Yes, Nicole.
And if I could direct your attention to the next exhibit for you, Exhibit 83. And again, what's up on the screen is that what you have before you as Exhibit 83?
Yes.
This is the same evening, is that correct?
Correct.
Do you know where in the house this photograph was taken?
I believe they call it their library. Maybe it's the room in the back.
And as far as what's contained in this photograph in reference to your friend Colin Albert, as far as his face, his arms, his hands, is that fair and accurate portrayal of what he looked like on February 11th?
Yes.
Thank you, ma'am. I have no further questions, Your Honor.
Okay, Mr. Yannetti?
Thank you.
Now, you claim that you took a screenshot of a text conversation that you had with Colin Albert on January 29th of 2022, correct?
Correct.
Those were the screenshots that were just shown to this jury this afternoon, correct?
Correct.
And you claim that the information on that screenshot actually existed on January 29th, correct?
Correct.
Did you tell your mother, Jennifer McCabe, that you had that text conversation with Colin Albert anytime after January 29th of 2022?
Objection.
Sustained.
Did you give to your mother, Jennifer McCabe, a screenshot of that text message conversation?
Objection.
Sustained.
It's fair to say that on January 29th, 30th, 31st, you did not turn over that screenshot to any law enforcement official, correct, of 2022?
No, I was never asked.
No investigator from this case ever asked you for copies or a copy of that screenshot of that text message conversation on January 29th, 30th, or 31st, correct?
Correct.
They also did not ask you for a copy of that screenshot through the whole month of February, correct?
Correct.
In fact, all of 2022, no investigator ever approached you to say, can I have a copy of that screenshot, correct?
Correct.
And in addition to that, you never called an investigator to say, hey, I have a copy of a screenshot of a text message conversation that I had with Colin Albert, correct?
No, it wouldn't have been relevant at that time,
Okay.
I believe, because Colin was not at the house and wasn't introduced as being there until later.
So your testimony today is that at no time in the year 2022 did you consider it relevant at all that you had this screenshot of this text conversation, correct?
Correct.
Leaving that screenshot aside, actually, before I leave that topic, you didn't turn over that screenshot of a text message until sometime during the summer of 2023, correct?
Correct.
About a year and a half or more after January 29th of 2022, correct?
Yes, when I was asked.
And by that time, the summer of 2023, you had already switched phones, correct?
Yes, I believe.
In other words, the iPhone that you had on January 29th of 2022, you no longer had possession of that physical phone, correct?
Correct.
Now, with regard to the timestamp on those messages, the conversation about I'm here, I believe gave the time 12:10 a.m., correct?
Correct.
Are you aware how easy it is to change that time?
No.
Are you aware that all you need to do is go from settings to general, and then there's a date and time that you can alter?
Objection.
Are you aware of that?
No, I didn't know that was a thing.
You know that when you set up your iPhone, you have to choose a time zone, correct?
Correct.
And you always choose the New York time zone, because that's where Boston is, right?
Correct.
Are you aware that if you go into settings, general, and then date and time, you can change the time zone to wherever you're going?
I guess I didn't. Once I set my phone up, I have no reason to change the time.
See? And in addition to changing the time zone, you literally can choose any time that you want. You could make 1:45 a.m., 12:10 a.m. in about 3 seconds. Did
Objection.
you know that?
Do you know that? Did you know that?
No.
But if, I'm not accusing you of this now, but if you had changed the time on that from a screenshot, we'd have no way of knowing, correct?
I guess.
Because what a screenshot ultimately becomes is like a photo, correct?
Correct.
It's not like you can edit it, right? I mean, the most that you can do is what we saw on the other photo that was displayed, which is kind of crossing out with a magic marker somebody's face or a time, right? That would be how you'd have to alter it, right?
Correct.
Now, I had asked you if prior to getting rid of your old phone and getting the new one, if law enforcement ever asked you to, go through the phone themselves, and you had said no, right?
Yes, they did not do that.
And they never asked to do an extraction on the old phone, correct?
No.
What about the new phone that you now have, that you got in December? Have the state police ever asked to do, have they ever asked to look through that phone?
They look, no, I don't think so.
You provided the screenshot that was shown to the jury today on August 25th when you talked to the state police in this case, right, of 2023?
Correct.
And when you provided them that screenshot, did they say, hey, by the way, can I look at your phone to see if it's on there?
Objection.
I'll allow that. Did they say that to you?
I don't remember.
But in any case, you never physically showed them your phone, right?
No.
You don't recall clicking on that text message app, the green app with the kind of white speech bubble. You didn't click on that and then click on the Colin Albert conversation and say, here it is, did you?
No.
And in addition to not asking you to see your new phone, they also did not ask you to do an extraction of your new phone, correct?
Correct.
And at some point in time, you realized that you'd have to be a witness in this case and have the unfortunate incident of having to talk to me, right?
Objection.
I'm going to see counsel at Sidebar for just a minute on this.
I just want to let you know, the other day when Brian Albert Jr. testified, he said he couldn't differentiate between the two hearings. One was for the harassment he and his family have received. I think you're opening the door if you get another answer like that, and the Commonwealth can run with it. So focusing on the screenshot, it may be why she didn't do it before, why she felt the need to keep these things.
I see where the court is going. Okay,
I'm just warning you on that.
I understand. I understand.
Thank you, Your Honor. I think the door is already open.
I think it is too. Okay.
Okay, and just to wrap this up, to this day, no extraction has been done on your phone, correct?
Correct.
No further questions. Thank you, Honor.
All right, Mr. Lally.
Thank you. Now, you were asked some questions about that time frame of August of 2023 when you were asked and you
turned over some screenshots to troopers from the state police, correct?
Correct.
You were asked about previous times, indicating that you weren't asked and it wasn't relevant, correct?
Correct.
Now, do you know why you were asked in August of 2023 versus any prior time period?
Because Colin Albert wasn't in the house, and then it was brought up here that he was.
And brought up where?
By the defense.
And around that time of August 2023?
I believe so, yes.
And with reference to relevancy, is that what you were talking about?
Correct.
And what, if anything else, are you're close friends with Colin Albert, is that correct?
Correct.
What, if anything else, has either your family or Colin Albert and his family undergone over the course of dependency of this case?
Objection.
No, the door's been opened. I'm allowing it.
Well, basically harassment.
And harassment by who?
Bloggers, people online.
And what, if anything, in relation to Colin Albert being in the house has occurred as far as the harassment that you're talking about?
Can you rephrase?
With reference to what you were talking about as far as the relevancy of Colin Albert being in the house at that time, what, if any, harassment was there in relation to that and in relation to Colin?
Well,
No, go ahead. She can answer.
Colin wasn't at the house, so he's being harassed he was not at the house when John was there, so I drove him home. So the people are harassing him saying he was at the house when it's not true.
When you speak about harassment, what specifically type of harassment are we
Constant phone calls, emails, awful messages.
Objection.
I'll allow it. Focus on this witness, not Colin Albert at this point.
As far as you and your family, what, if any, type of harassment have you received?
People showing up at our house, people emailing my school, just like a lot of harassment. Can I have a moment, please?
Sure.
Okay, I'm sorry. I have some, thank you.
And how long a period of time has that persisted for?
Very long time.
Thank you. I have no further.
I have nothing further.
All right, Ms. McCabe, you're all set.
Thank you.
Your next witness, Mr. Lally.
Yes, Your Honor. Call multiple call Colin Albert to the stand.
Thank you. Be seated. Court is in session.
22117 Commonwealth versus Karen Reed. Counsel?
All right, counsel wanted to see me at Sidebar?
We don't need to be seen at Sidebar, Your Honor, but I do need to be seen about an issue from yesterday.
Like to be heard?
Well, yes, I would.
Okay, I'll hear you. What is it about?
Your Honor, we are not only renewing our objection to the alleged harassment evidence that came in yesterday, but we're specifically moving to strike that testimony and specifically asking the court, before we go starting to instruct the jury that they are to disregard that evidence. And I wanted to point out to the court that it is our view we didn't even come close to opening the door to that evidence. I had just asked the witness if she had turned over those text messages to the state police when she spoke to them on August 25th of 2023. I've asked every witness when was the first time that they spoke to the state police. That was the first time Allie McCabe spoke to the state police. None of that conversation had anything to do with harassment whatsoever. It was strictly related to the death of John O'Keefe and the investigation of John O'Keefe. I stayed completely clear of any discussion of harassment whatsoever. I only focused on the federal grand jury and the approach by the state police on August 25. I opened no door. I didn't even approach the door. And yet, that evidence came in. It led to a moment where, that Mr. Lally, I believe, has been waiting for, which is for a witness to break down on the stand and feel sorry for themselves to gain sympathy before this jury. It was prejudicial to our client. It's prejudicial to our defense. It is error, and we're asking the court to correct it.
All right, what do you say, Commonwealth?
Your Honor, counsel absolutely opened the door as far as the questioning was concerned. It was not just the characterization of the questioning is just simply inaccurate. As far as the questions that were posed to the witness, it was more geared towards why, implying that the witness only provided this after testifying at the other proceeding or being questioned about it in that environment, and that's the only reason that she had these messages, and why hadn't she turned these messages over earlier? And that is in direct response to the harassment that that witness and her entire family, as well as Mr. Albert, had sustained as a result of actions by several different parties, including counsel. So for those reasons, it was proper. There was nothing, I don't think it was more than 5 minutes of testimony concerning it, and it was because counsel opened the door to it.
Okay, thank you. All right, so Mr. Yannetti, I remember clearly the lines of inquiry that you initiated. So I disagree with you in the strongest way possible. You've made your record. Your motion's denied.
Thank you, Your Honor.
Okay, so let's bring in the jurors, please.
Who's Courtney Proctor?
She's friendly with my aunt, Jillian.
I'm sorry?
My aunt Jillian, she's friendly with.
When you say friendly with, describe that. What do you mean by friendly with?
I know that they're pretty friendly.
Have you ever been to Courtney Proctor's home?
Yes.
How many times would you say over the years?
4 or 5, maybe.
Her family is close to your family, it's fair to say.
Not that close. Close though.
When you say not that close, but close though, what does that mean?
I'd say we're more close when I was younger, not when I got older.
Okay. How old are you now? You're 20?
Correct.
May I approach you? Okay. I have a photo I'd like to show Mr. Lally first. May I?
Yes.
Thank you. Take a look at that photo and tell me if you recognize it. Just look at it to yourself, please. Let me know after you studied it for a second.
Yep.
You recognize the photo?
Yes.
Who's in that photo?
Objection.
So the objection sustained as to the content of the photo. Did you want to come to sidebar and explain this to me?
This photograph establishes a close familial relationship between the Albert family, specifically this witness, and the Proctor family.
Okay. He testified to that just now.
I know he did, and I want photographic evidence of it as well. The jurors are entitled to see it. I'm about to ask him a series of questions about being in a wedding, being part of the wedding party, the fact that that's him, the fact that that is Michael Proctor.
Okay. So Michael Proctor, because this is double D for identification, is what looks to be a young man on the left-hand side, far left of the photo. And Colin Albert, this witness, appears to be the child standing next to a bride. How many years ago is this?
I want to say it was 2011, either 12 or 13, 12, I think.
Okay. What is the Commonwealth's position on this?
The Commonwealth objects, as it is irrelevant and the time period is far too removed to have any relevancy whatsoever. Furthermore, any relationship between this witness and Julie Proctor, again, goes to bias.
Goes to what?
It could be proper impeachment or bias questioning for the trooper. But again, impeachment bears to the witness on the stand pursuant to the case law. This witness is not an investigator. His bias has absolutely no relevancy whatsoever. There is no bias just because he knows a trooper.
I couldn't disagree in stronger terms. It is both of their biases, and the fact that the photograph was taken several years ago establishes a long-standing familial relationship between this witness and the investigator, who ultimately was the person in charge of, and did, in fact, conduct the investigation. It is the level of comfort they had with each other. The bias of Trooper Proctor showed the lack of investigation on Trooper Proctor's part of this particular witness. He's obviously a seminal witness. The prosecution called him to the stand. We didn't call him to the stand. The jurors are entitled to realize the depth and nature of the familiar relationship, and I think the photograph speaks for itself.
So the photographs are cumulative.
I'm sorry. The photographs...
Cumulative. I mean, he said not that close with the family, but close. And then he said more close when I was younger. So I understand you want this in. You need to establish a little bit more of why. I'm not letting it in now. I'm not inclined to let it in. Let's see if you can develop it a little bit more, which doesn't mean that you can describe the picture intentionally.
You're saying it's cumulative. If I can't use the photo and I can't describe the photo, how am I supposed to establish to the witness's satisfaction or the court's satisfaction that the witness has a deep familial relationship in the photo if I can't even describe it?
You can talk about it without, you are a skilled trial lawyer. You know how to get this in.
I know.
So I'll give it back to you and we'll see where you go with it. It's not coming in right now.
May I give it back to the witness so I can ask him about it?
Sure.
May I approach them?
Yes.
Thank you. Thank you. Mr. Albert, approximately when was that photograph taken?
Objection.
No, we can get that, but we'll answer that question.
10 years or less ago, I'd say. I don't.
You were the ring bearer in Courtney Proctor's wedding, were you not?
Objection.
I'll allow that.
Correct.
So when you say we're friendly, but not that, or we're close rather, but not that close, you were actually close enough to be a member of her wedding party when she was married to her now husband, correct?
When I was younger, correct.
Well, of course it was when you were younger, 10 years ago. Is that yes?
Yeah.
That's my question. So for at least a decade, your family and the Proctor family has been close enough such that you and Albert were in her wedding, correct?
Objection.
Ask that differently, Mr. Jackson.
For the last, well, at least at that time, 10 years ago, your family was close enough to the Proctor family such that you were a ring bearer in Courtney Proctor's wedding, right?
Correct.
And who's Courtney Proctor's brother?
Michael Proctor.
And is Michael Proctor in the photograph that you're looking at?
Yes.
The person on the far left
Correct.
looks like he's in a tuxedo.
Correct.
You were also in a tuxedo.
Objection.
Sustained.
What I'm getting at is you all were part of the same wedding party, correct?
Correct.
And that's a photograph of Courtney Proctor's wedding and the entire wedding party, correct?
Objection.
Sustained.
Is that a photograph of a wedding party?
Objection.
Sustained.
Your Honor, may we approach?
Yes.
I don't understand how this is cumulative or not relevant. They are literally standing in the same wedding party. And when I ask if that is a wedding party, counsel is objecting and it's getting sustained. What more can I ask about the foundation of this photograph?
So I don't see why you need the photograph of a wedding that's 10 years ago.
Because I'm choosing what evidence I want to present to a jury to establish bias. It's one thing for them to hear about it. It's another thing for them to see it. A picture is worth 1,000 words. This is basic hornbook trial lawyering.
Okay, I disagree with you on that. Tell me about your specific reason.
My specific reason is because that man on the left interviewed that young man, a now grown man, on the right.
And you just got that through the witness.
I realize that. But the visual of having them in the same wedding party at the same time is powerful information that jurors can weigh and balance in determining to assign credibility not only to this witness as to his description about the relationship with the Proctors, but ultimately with Michael Proctor and his relationship with the Alberts.
What do you say, Commonwealth?
Your Honor, the fact that he is in this wedding party as someone 12 years ago when he's a child, again, the relationship to a family does not equate to a relationship to an individual. So the fact that he's in a wedding party as a ring bearer and the brother of the bride is also in the same wedding party 12 years ago has absolutely no relevance whatsoever to 10 years later. Any interaction they may or may not have had. And as far as the investigation is concerned, again, this is a trooper who, yes, he's involved in the investigation, but so are...
Is it in evidence that he interviewed this witness?
Yes. He was asked by Mr. Lally yesterday.
Fine. And you told me that you were going to go through the ease with which he feels with the investigator, and then the investigator not going further. You didn't do any of that just now.
It's coming. I was going to publish...
It might help you get the photograph in.
Okay.
Yes.
Thank you. Mr. Albert, I want you to look at that one more time. Both you and Michael Proctor are depicted in the photograph, correct?
Correct.
How long have you known Michael Proctor?
Since I was a little kid.
And you've known him well enough to know, I don't want you to tell me or tell the jurors, but you know where he lives.
Yeah.
You consider the Proctor family close to your family?
Yeah.
During the course of, for instance, just as an example, during the course of this event, joyous event at a wedding, you actually sat at the head table along with the Proctor family because you were given the honor of being the ring bearer in Courtney's wedding, correct?
Correct.
And you know, of course, that being in a wedding party is reserved for those special family members and friends, correct?
Objection.
Sustained.
In your mind, was that a special honor?
Objection.
Is that what you thought when you were little? When you were in that?
I'd say so, yeah.
Okay.
And you were never interviewed by Canton Police Department in connection with this case, correct?
No.
How many times were you interviewed by the Massachusetts State Police in connection with this case?
Once.
And that was in July of 2023, correct?
I don't remember exactly when it was.
About a year and a half after the events in question. Is that right?
Around there.
Okay. Would it refresh your recollection if you saw a copy of a report of that interview? Just to get the date?
Sure, yeah.
May I approach now?
Yes.
I may have just a moment.
Yes.
Take a look at paragraph 1. It's in the middle of the paragraph. If you'll just read that to yourself, please. You got that?
Yeah.
You saw the July 18 date,
Yes.
2023?
Yes.
Does that refresh your recollection that that was the first time you were interviewed by the Massachusetts State Police?
Correct.
May I approach now?
Yes.
Thank you. Did you find that the interview with Michael Proctor was consistent with the relationship that you've had with him your whole life? Meaning, he's always been friendly to you, he was just as friendly in that conversation.
Not really, no.
How is he different?
I'd say more professional.
Okay. Obviously, he was doing a job, correct?
Correct.
But when you walked in, you recognized him.
Yes.
He recognized you.
Yes.
You made natural greetings with one another, correct?
Correct.
He questioned you about a few things.
Correct.
He didn't look at your phone. He didn't ask to take your phone away from you.
No.
He didn't ask to seize your phone or seize any other physical items from you.
No.
You weren't asked to come down to the police station and sit in an interview room or an interrogation room, were you?
No.
Matter of fact, where did the conversation take place in those 10 minutes?
In the DA's office on Shawmut Road.
DA's office on Shawmut Road. Who else was there other than Trooper Proctor and his partner at the time, Trooper Clark?
Can you
Who
repeat?
else was there? Was it just Trooper Proctor, Michael Proctor, and Clark?
Yes.
Okay, so it was just the three of you.
Yes.
And Trooper Proctor was the one that was sort of leading the conversation.
Yes.
And then when it was done, he said, "You're free to go."
Correct.
And he didn't take your phone.
Nope.
He didn't ask you to look at any text messages.
Nope.
He didn't look through your phone.
Nope.
He didn't take any screenshots or videos of your phone or the contents of your phone.
Nope.
Just let you walk out the door.
Correct.
Your Honor, may I publish the photo?
Why don't you come over here for just 1 second? May I have that, please?
So, Mr. Jackson, are you telling me now, after this line of questioning, that this photo that I view as cumulative is essential to the bias of this witness because this witness is your third-party culprit or a third-party culprit witness of yours? Is that why you intend to introduce this exhibit?
No, I don't believe that we are forced at this point to put him in a category of a third-party culprit. Evidence is still coming in from the Commonwealth. The evidence is still being explored by the defense. This photograph is specifically to establish the bias and lack of investigation, or lack of proper investigation by an investigator. This is evidence that that investigator never should have been interviewing this witness in the first place. It should have lasted far longer than 10 minutes. They should have done their due diligence. They did nothing. They never looked at phones. They never looked at text messages. They never looked at the phone. They never sought an extraction. This was a 10-minute conversation with someone a year and a half after the fact that they left pretty much alone for a year and a half, notwithstanding the fact that he was at the house for the interview at or around the time that John O'Keefe was injured. And court seems to have an issue with establishing basic bias, and that's part of our defense. This entire investigation has been crippled by bias, personal relationships, favoritism, etc. This is absolutely some of the best evidence we have of that. It's not cumulative of anything. We haven't put any photographs in. It's not like this is the 10th photograph, one, and it's certainly not more prejudicial than probative. It's highly probative to the relationship and the interpersonal relationships that these witnesses have with this, especially this witness has with the Proctor family.
What is the Commonwealth's position?
The Commonwealth's position is the same. It's not evidence of that. And as far as it bears on the investigation, that does not bear on this witness. He doesn't control what questions are asked or what things are asked of him. Furthermore, as far as anything to do with third-party culprit, there is no evidence of third-party culprit because there is no evidence of a third-party culprit specifically as it relates to this witness or numerous witnesses who have already come and testified before this jury that he wasn't even there at the same time as Mr. O'Keefe was.
All right, so I asked you that, Mr. Jackson, because I think that might be a basis to let it in. But on that basis, it is strictly cumulative and it's not coming in. Is there anything else you want to say?
If we develop a third-party culprit defense to our satisfaction, ultimately that we are comfortable with, and ultimately the court is comfortable with, I think that should come in for that purpose. However, irrespective,
you can renew it.
I appreciate that. I appreciate the court leaving the door open, but I believe strongly that this goes to a Bowden defense as, well, which is what we are really exploring at this point. It's a lack of investigative interest in this witness. Why? Because he's a kid that he's known his whole life. I mean,
I get all that. You got all that into evidence, which is why I contend your own photograph is cumulative. But I will leave it open if you tie it in otherwise. And just so you know, it's double D, okay?
Thank you.
May I inquire you?
Yes.
Thank you. Mr. Albert, I want to shift gears for a quick second. On July 27th, you and your attorney appeared at a hearing in a separate proceeding, correct?
I don't.
Let me ask it a different way. You testified at a different proceeding, not this trial, but a different proceeding.
Correct.
Okay. You put under oath. You appeared with your lawyer. You gave testimony, and that's part of what you looked at a second.
Correct.
Okay. But when you met with Michael Proctor, you did not feel the need to take an attorney with you. It was just you, Michael Proctor, and Investigator Clark, correct?
Objection.
That's sustained.
We were shown a photo yesterday of you in February of 2022 with your aunt. Remember that photo? Mr. Lally showed you that photo?
Correct.
And he said he wanted you to pay special attention to your face and hands and extremities. Asked you if there was anything unusual about that.
Yes.
You said no. In that photo, absolutely nothing unusual in February of 2022 about you, your face, your hands, fists, nothing, right?
Correct.
I want to draw your attention to February 26th, same month, less than a month after the incident. You were at a place called Fenway Johnny's with your buddies, weren't you?
Correct.
Then I have two documents I'd like to mark for identification with the court's permission to show Mr. Lally.
Okay.
Can I present these to the witness?
Yes.
May we approach?
I may as well see them. I'll end up seeing them anyway.
So tell me what you are planning on doing, Mr. Jackson. Start with FF.
FF is just an enlargement of EE, which is that single photo.
Okay, so E, just for the record, appears to be 6 thumbnails with an additional 6 partials.
Yesterday, Mr. Lally opened the door to this line of inquiry presenting a photograph in February that he claims was in February of this particular witness.
Yes. I was just trying to go back and find the date. What was the photo that's in evidence, like February 11th or something?
That's what the testimony was, which we dispute. But given the fact that he opened that door, he specifically asked the witness questions about his face, his hands, his extremities, etc., implying that this witness, as having been in a fight, he wasn't in a fight. He's got no injuries suggestive of fight, etc. That particular photo is manipulable. That photo was taken by a family member. It was on their phones. It was on their own data.
So I just have to ask, though, because I missed it. Where is there evidence that it was manipulated?
I think that the fact that it's manipulable is the evidence that needs to be weighed and balanced. I don't have to prove that it was manipulated, but I
can say that there is no evidence of that. But go ahead. I'll hear this.
So what I can prove is that on February 26th, that photo is not manipulable because it doesn't belong to any of the parties. This was taken at an event logo. It is taken by an event staff member. So they had no access to dates, times, metadata, changing anything, etc. It shows very clearly that this witness appeared significantly injured, white knuckles indicating a fight, indicating some level of violence, indicating a physical altercation, etc.
What do you say, Mr. Lally?
Honor, I don't know that there is any evidence that this came from a source or that it's not able to be manipulated. I don't know what that is on the EE that's on the side there, as far as whatever labeling is on there is complete and utter hearsay. I don't know what any relevancy any of the other photos have. But as it pertains to this event, it is irrelevant. There is no evidence that the first photograph is manipulated. There is no evidence that the first photograph wasn't taken on February 11th. And if it was, then there is absolutely no relevancy to this.
Mr. Lally did not have to put that evidence in. He chose to open the door to this. He's put the relevance of this right before the court. He doesn't get to have his cake and eat it too, saying there's no injuries and knowing full well that we have a photo that shows significant injuries.
All right, you're telling me it's February 26th, and just so it's clear, EE is something from Facebook from someone named Caitlin who posted it. That's not a Caitlin in this case, correct?
No.
And it's a bunch of young adults posing and partying. What I'll let you do, because it appears that the injuries to Mr. Albert's knuckles on his right hand in FF are not recent, I will let you put in Colin Albert, 34, means he posted this himself?
I'm assuming he did.
Okay, so the Colin Albert 34 will come off because you don't know. You can show him. I'm not letting EE in.
I would say I'll redact everything on EE. He has already established I don't need EE. He just established that he was there on the 26th. That's all I need.
Right. So you can show him this, and you can put this. I realize it's post February 11th. Mr. McDermott, could I have that photograph? What exhibit number is the photo?
I think it's either 83 or 84.
83 or 84?
It's in the book. Ms. McLaughlin is going to get it.
Okay. Do you know if you can see his right hand in that? I think it's hanging down by his side and you can see it.
It's around the neck.
You can still see it, yes.
But there was a separate one where he doesn't have his arm around somebody, and I think that's the right hand. Is that the right hand?
I believe it is, yes. Your Honor, for the record, also with those exhibits, as the court had requested, we redacted the dates off of those.
Yes. Thank you. Also showing right knuckles in 82. In 83, you can see his right hand. All right. I am going to give you that. It's giving you quite a bit of leeway, Mr. Jackson, so that has to be redacted if you intend to show it. So these have exhibit numbers on them. These are trial exhibits. We need these.
I'll ask my IT person to just show this portion without the...
Yes. I don't think you can separate that.
No, that's impossible.
DeJohnny's. All right, so I'll give you E, in case you need it because he doesn't remember.
Understood. Thank you.
You need to physically put it in evidence first.
You see that photograph that's being displayed?
Yes.
Are you in that photograph?
Yes.
Which person are you?
In the middle.
And about what time of day was it? That's you in the middle?
Correct.
Okay. At what time of day was this taken?
Not sure.
Was it at an event of some sort, or just you were at a bar?
Just at a bar.
Okay. I want you to take a look at your right hand. Can you see from there clearly your right hand?
Yes.
What do you notice about your right hand?
It's cut up.
Your knuckles are injured, correct?
Correct.
Now, you didn't take this photo, did you?
Nope.
That photo was never on your phone. In other words, it wasn't a friend of yours that took the photo, correct?
No.
This was taken by an event staff member, is that right?
Correct.
It was later posted on social media, isn't that right?
Correct.
You could not access the metadata, you couldn't access the time and date of that photo, correct?
I'm not sure what you mean by that.
You couldn't manipulate the time or date this photo was taken?
No.
This photo is completely sort of out of your control, isn't that right?
Correct.
And it was controlled by the event staff at Fenway Johnny's.
Correct.
And on February 26th, less than a month after the incident at Fairview, that's what your right knuckles look like, correct?
Correct.
And this is a true and accurate depiction of your condition on or about February 26th, correct?
Correct.
How'd you get those injuries, Mr. Albert? We can lights up.
I was at a party, a house party my senior year, and I remember it being icy out, and it was kind of like a steep hill of a driveway, and I was walking up the driveway, and I slipped down the driveway, and I tried to catch myself, but I had something in my left hand, so I had tried to brace myself with my right hand, and I ended up sliding a little bit down the driveway.
What'd you have in your left hand?
If I remember, it was either my phone or a beverage.
So, according to you, you fell on ice and injured your knuckles, as we just saw in that photograph, right across the top of your knuckles.
Correct.
Okay. So you fell onto, what, pavement, asphalt?
Yes.
And you braced yourself when you fell, your entire body weight, by putting your right hand down in a fist, and you injured your right fist, just the top of the knuckles on your right fist when you fell down.
Correct.
Seriously?
Objection, Your Honor.
Sustained.
Did you post a video You threatened that you're going to.
Objection, Your Honor.
The objection sustained. I'll see you at sidebar on this. I'm familiar with this.
All right, so this is one of the videos that people were kind enough to send me. There are two drunken videos with this kid. Is that right that you sent me?
I don't know if they are drunken or not, but 2 videos of this kid.
Okay.
One is just to define them. One is the Advantage Boys, I'll fuck you up, and one is KO Bang Bang. 2 separate videos.
Okay. Neither one of them depicts fighting, right?
They both threaten fighting significantly.
What do you say, Mr. Lally?
They are videos of a high school kid talking about a hockey team. There is no evidence that any fight ever occurred between himself and this group. There is no evidence that anything was ever actually followed up on. So it doesn't go to bias. It doesn't go to impeachment. It goes strictly to character, which is subject to the motion in limine, which the court allowed as far as reference to any of these witnesses. So I don't see any relevance whatsoever to, it has nothing to do with John O'Keefe. It has nothing to do with anybody that has anything to do with this case. Online, social media fodder is what it is.
That's not online social media fodder. When he's threatening to, quote, beat your ass, pardon my French, to fuck you up. I'm going to fuck you up. I'm going to beat your ass. KO means knockout, bang, bang. These are not the innocent musings of a child. These are a grown young man making violent threats toward other individuals, and he has just testified, I've never been in a fight in my life. The Commonwealth is doing their absolute best to sanitize this person's reputation. It is wrong. It is a fraud on the jury.
I disagree with all of that, but...
The court disagrees that the Commonwealth is trying to sanitize this young man as an Eddie Haskell who has never been in a fight.
Hold on. And committing a fraud upon this jury.
No, I'm not saying that.
You did just say that.
I'm not saying that he's committing the fraud. I'm saying the witness is committing the fraud on the jury. It's not a true and accurate representation of his...
So explain to me. We are going to need to play the video and have a voir dire.
I'm happy to.
All right. I thought it was 2 different videos.
They are.
Which one are you planning to try and introduce?
I was going to do Advantage Boys first, and then the Bang Bang second.
I don't remember. I watched these whenever you gave them to me. I just remember 2 drunken videos.
It's been a while. They are probably 10 seconds each. They're not long. Maybe one is 15 seconds.
So what I'd like to do is we will let the jury out. I'd like to see the videos again on the screen as the jury would see them.
Sure.
And then we'll see them. We'll have a voir dire of this witness. Then I'll hear your arguments. Then I'm going to go watch them again in my lobby. That's how I'd like to do it.
Yes, Your Honor.
So it will be a long break for the jurors, and you all will get a very short break afterwards. Okay?
Understood.
So I'm going to send you out for a recess. We have some work we have to do here. It wasn't early enough for me to get you coffee and bagels. I apologize for that, but we'll be a little bit. So we'll send you out for the morning recess.
All eyes on the board, please. Follow me.
That's all I have this time, Your Honor. Thank you.
All right, I will hear you.
Your Honor, if we could make the argument outside the presence of the witness.
Yes, I'm sorry. I'm going to ask you to step out of the
Thank you, Your Honor.
Hold on.
Oh, I'm sorry.
Oh, okay. Yeah. Okay, yeah, you cannot hear in that background.
No problem. I appreciate you giving us the opportunity. Your Honor, it's very clear that these videos are highly, highly relevant, given the sanitized testimony that this witness has tried to present to this jury. He's indicated that he's never been in a fight. He doesn't have any violent proclivities. He doesn't have any violent tendencies. It's not in his countenance to do this. Mr. Lally opened this
So
door.
you only got that through the voir dire?
Understood.
Okay, so the violent tendencies only came in through the voir dire.
Well, that's not true. When in front of the jury, he said, "I've never been in a fight."
Okay, but that specific question, you said violent tendencies, it was unobjected to, but that was voir dire.
Understood. Mr. Lally clearly opened this door yesterday. He presented a photograph or a series of photographs with this witness's family. His arm draped over his aunt. He's with his mom, looking very family-oriented, etc. And Mr. Lally went further than that and specifically said, "I want you to take a look at your face, and your hands, and your extremities. Do you see anything unusual or odd about that?" That's why I believe the court allowed, based on the testimony today, allowed the photograph in February of 2022 of the actual photo that cannot be manipulated. It's in the hands of a third party of the busted and injured knuckles on this witness's right hand. He then said, "I've never been in a fight." Those two videos belie that testimony. There is no way to look at those two videos and say, this is not relevant to the issue of whether or not he has been in a fight.
But tell me how whether he's been in a fight is relevant to an issue in this case. That's what you have to do.
Because the police should have, the Massachusetts State Police should have, if they were doing their due diligence, they should have investigated this young man. They should have investigated every single person that was in that house, in or around the home of where John O'Keefe was found, the Albert home, and they didn't. They did nothing to investigate whether or not there was someone in the house who tended to fight, who wanted to get in physical altercations, who had a propensity to get in physical altercations, who was a fighter by nature, who threatened to fight, who threatened violence. That's what this young man has indicated he does constantly. I'm surprised he didn't show up in this hearing with busted knuckles.
So does this go to your third-party culprit defense?
It goes to both. It certainly goes to both, but yes, it also goes to our third-party culprit defense as well. This is a focus of, I believe, this should be a focus of the juror's attention in terms of, is there a third party who could have done this that evidence points to that may have done this? Absolutely. This evidence, what we now have, points directly in that it's focused in that direction. So yes, both it should have been investigated, and Colin Albert is somebody that the jurors should focus their opinion on or their attention on to determine whether or not he could have or was involved in the death of John O'Keefe.
All right, Mr. Lally.
Yes, Your Honor. Commonwealth would submit did not open the door in reference to this, showing a photograph of someone and what they physically looked like. There was no suggestion. The only questions that were asked about fighting or anything of that nature were by counsel. So counsel thinks he opened his own door. I don't think that's exactly how that works. This is nothing more than rank speculation. It has nothing, bears no relevance whatsoever to this case. You're talking about something that is dated at least a year, if not two, prior to the incidents in this case.
But what if it's, as Mr. Jackson pointed out, the prior testimony, his senior year, which is, of course, is much closer?
Well, I think even assuming that, as far as relevance is concerned, Your Honor, there is no evidence here of a fight at all. There is no evidence that this witness was even present at the house at the same time as the victim. There's no evidence of any animus between this witness and the victim. There is no evidence whatsoever, as I stated, that he was even present at the same place at the same time on the night with John O'Keefe, on the night that John O'Keefe was killed. There is no evidence from even these videos of any physical altercation having taken place. So whatever juvenile beef that he and his friends had with individuals from another town, there's no evidence whatsoever of physical altercation. There's no evidence that there's a physical altercation even in this case. So to allow counsel to introduce this purely for prejudicial reasons and to invite the jury to speculate as to what it is essentially does nothing but divert the jury's attention away from the facts of the case and what the evidence of the case is, and more so is just there's no evidence of anything in this case.
May I begin briefly?
Yes.
In terms of evidence of a fight, I don't know what Mr. Lally is talking about. He says there's no evidence of a fight in this case. John O'Keefe looks like he had been beaten to death. He's got two black eyes, a laceration over his right eye, a laceration over his nose, a giant wound on the back of his head, and he doesn't look like he was hit by a car. He looks like he was in a physical altercation. It's as plain as the nose on your face, and we have evidence that we have witnesses who are going to propound that evidence and present that evidence. So Mr. Lally and the Commonwealth can take whatever position they want to. If they think those injuries are consistent with being hit by a 6,000-pound truck, they can knock themselves out. That is not the state of the case, and they don't get to dictate the state of the facts. The facts speak for themselves. Second, with regard to whether or not Mr. Albert was home that night, or at the home that night in a position to be able to engage in a physical altercation, which, by the way, takes about that long, that is predicated on his own family members covering for him. Every one of the witnesses who testified basically are friends and families of the Alberts. And keep in mind, Your Honor, I don't think it's lost on anybody that Colin Albert was hidden, specifically and intentionally hidden from all of law enforcement for the first several months of this investigation. Nobody was willing to even say he was at the house. That is highly, highly suspicious. Given the gravity of what we have now, I would take an issue with one thing Mr. Lally said. He said this diverts the jurors' attention. I would agree it diverts their attention. It diverts their attention to somebody who possibly could be involved with this, who was not properly investigated. And I'll submit.
Okay, so may I have those 2 flash drives, please? Yes. No, I was asking their court reporter. All right, so why don't we take a 15-minute recess? I'll look at these and we'll come out. I actually will see counsel at Sidebar. I wasn't sure this was coinciding.
So, separate and apart from whether the Commonwealth opened the door, I really appreciate the opportunity to have been able to view these a couple of times. With the record before me, I am going to let it in. The Commonwealth's objection is noted.
Thank you.
Okay.
So, Jim. And, oh, actually, they'll need to be passed down to Nancy. Sorry.
I'd like you to take a look at a video. It's been marked for, sorry, it's evidence number 86. I'm going to play this short video for you, and then I'm going to ask you a couple of questions.
Yo, you're Yannetti boys. I will beat all your asses. I promise you, I will fuck you all up. Pull up, bitch.
Your Honor, with the court's permission, could we play evidence number 87?
Yes.
Yeah, thanks, bro. Fuck you. Yeah, fuck you. Let's go, boy. You can rock up. Hello.
May I inquire?
Yes.
Mr. Albert, who is that in that video?
Me.
Was that taken around the same time?
Yes.
You indicated you're a bitch, bro. Right?
Correct.
Was that a threat?
Yes.
More of an insult?
Yeah, more of an insult.
Calling someone out?
Yep.
Making them feel bad?
Yeah.
Prompting them to maybe fight?
Objection on.
Well, I'll ask that question differently, Mr. Jackson.
Also called him a pussy, didn't you?
Correct.
Derogatory comment?
Correct.
And then you said, KO, bang bang, right?
Correct.
What's KO mean?
Knockout.
And what does bang bang mean?
I'm not sure, honestly.
You were just talking about knocking somebody out.
Correct.
And the bang bang just sort of flowed.
Exactly.
Was that a threat?
Yes.
And these threats that we've just talked about, that we've just seen, these are threats of physical violence, right?
Correct.
You're not threatening to hurt their feelings or send them a mean text, right?
No.
You're threatening to kick their ass, right?
Correct.
To get physical, right?
Yes.
To ball up your fists and beat the shit out of them.
Objection.
Can you answer that? Will you answer that, please?
Yeah, can you repeat the question?
Probably shouldn't. You were threatening to ball up your fist and beat the heck out of them.
Objection.
I'll allow it. Is that what you were threatening to do?
Yes.
When you testified in a separate proceeding in July of 2023, you actually showed up for questioning live, correct?
Yes.
And you showed up at the time in July of 2023 with your knuckles busted up again, didn't you?
Correct.
And you were asked about your knuckles at that time, correct?
Correct.
And that time you said, oh no, I didn't fall down on black ice and slip and break my fall with my knuckles like you said here. You said, oh, I hit a heavy bag and busted my knuckles up on a heavy bag, right?
Correct.
So that heavy bag was you practicing boxing, right?
It was me getting cardio, yes.
Which is in a form of fighting.
In a form, yeah.
Punching a bag.
Yep.
That's how you choose to do your cardio.
Sometimes.
And you're right-handed?
Yes.
And it was your right hand that was busted up.
Correct.
So when you throw your hardest punch, that's with your right hand, isn't it?
I'd say, I'm not sure. I'd say they're equal.
You're equally strong with both hands.
I'd say so.
So in your words, you could fuck somebody up with either hand, right?
Objection, Your Honor.
You answer that.
No, I'm not saying that.
That's all I have, Your Honor.
Okay, Ms. Lally?
Thank you, Your Honor.
Your Honor, just before I begin, may we approach?
Okay.
I just wanted to clarify with the court, based on my understanding of the question, I believe the door has been opened as far as harassment with this witness as well, and I intend to go down that road.
Okay. Do you want to point to specifics?
Like specifically what was asked as far as the timing, as far as you never talked about this case with family or friends for 2.5 years, and then you indicated no just more recently. And I think in order to explain sort of why that is, it is in reference to the harassment this witness has sustained.
What do you say, Mr. Jackson?
With all due respect, that is a ridiculous argument for opening the door. Mr. Lally is desperate to get anything he can in about these witnesses being harassed. I did not come anywhere close to asking any questions, especially about yesterday. My questioning was tight and thoroughly narrowly tailored to issues concerning this witness's credibility. And I questioned based on the door that opened of his violent tendencies. I didn't come anywhere near asking a question about whether or not he had been harassed, whether or not he had been contacted by the police based on harassment. I asked him, we have to be able to ask, how many times have you spoken to the police about this case? This specific case, not harassment. And that's what I asked.
What do you intend to ask? I do have in my notes, at the very beginning, I wrote down that I believe the door was open, Mr. Jackson. Frankly, I was surprised. It is in the beginning when you went through the whole litany of the preparation and just a couple of other things that I didn't get to write down. You've been thinking about this case. How long have you been thinking about this case? And he said, since people started writing about me on the internet, which was in response to the question as phrased. But tell me what you intend to get into, Mr. Lally.
Just following up on that, Your Honor, as far as people writing about you on the internet, what was that? When was that? What did that entail?
All right. I'm going to give him some headway on that. Like I said, frankly, I was surprised.
We are getting to a point, Your Honor, where we can't ask anything. We're being hamstrung because Mr. Lally is going to come up with, I'll say, what color is the sky? And he's going to say, well, he said blue. He felt blue in years past because he's been harassed. It's such a square peg in a round hole. We are getting to the point that we can't defend this case without fear that...
You just have to be careful and skilled, counsel.
I think I am careful and I think I am skilled. I didn't come anywhere close to opening the door, Your Honor.
Unfortunately, I believe you did. So I am going to give him a little leeway on this.
Now, you were asked some questions on cross-examination regarding whether or not you've been thinking about this case for the last 2.5 years. Do you recall that?
Yes.
And you indicated that you would not, correct?
Correct, sorry.
And you had indicated in your testimony in response to that questioning, essentially not until people were writing things about you on the internet, correct? Correct. Can you expound upon that? Can you explain to the jury sort of when that occurred and what were the things that were being written about you on the internet?
I'd say about a little over a year it started when people on Twitter, Instagram, social media were just coming at my family, calling us murderers, harassing us, showing up to our doorsteps, our sports games. I mean, we couldn't leave the house without people taking pictures of us, and it's very terrible.
And how long has that gone on for?
The past year and change, a couple months. Past year and a couple months, I'd say.
To be clear, that night that you were at 34 Fairview Road at your uncle's house, January 28th and 29th, at any point in time did you see John O'Keefe at that house, come into that house, around that house, at any point in time did you do that?
Never.
Nothing further.
Nothing, Your Honor. Thank you.
Okay. All right, Mr. Albert, you're all set. I think that piece of paper goes back to Mr. Jackson. Did you leave something on the witness stand?
Thank you, Your Honor.
Okay. All right, Mr. Lally, your next witness.
Yes, Your Honor. The Commonwealth will call Mr. Matthew McCabe to the stand.
Okay.
I woke up to screams in my bedroom.
Your Honor, may we approach just briefly?
Okay.
I'm sorry. This is just selfishly on my own part. I was just looking at the time and I don't know. I'm not going to finish with him. And this might be the easiest place for me to pick up tomorrow with this witness. I can keep going if the court wants. I am completely fine with that.
I was trying to figure out whether you were going to start with 7 minutes. I didn't know if we had any more. Would you have started with 7 minutes left?
No.
Okay.
Yesterday, I should have come to Sidebar to say, should we end early? It was yesterday or the day before. Anyway, no, I'm fine with that.
I don't have a problem with it.
Okay.
Any surprises tomorrow? I mean, evidentiary issues? I'm going to let the jury go.
That's fine.
So we will send you home. Please make sure you follow those 3 cautions. Do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Tomorrow's a full day. We'll see you tomorrow. Thank you very much.
All right, so the court, please.
Hold on. We are back on the record.
I just mentioned to Mr. Lally, he's been kind enough to give us advance notice of the witnesses that he has lined up for the next day. And tomorrow, after Matt McCabe, we've got Jen McCabe, Carrie Roberts, and then 2 witnesses that I think are going to be fairly brief. So I just wanted to make sure there is nobody else after that, just so that we have binders and binders and binders of information.
I understand. This is how I always tried cases, and this is how the Norfolk County DA's office... who do you expect to have tomorrow, Mr. Lally?
I anticipate we can finish up with Mr. McCabe. Then Jennifer McCabe will be after that. Carrie Roberts will be after that. And then Laura Sullivan and Marietta Sullivan.
Okay.
But my expectation, just on sort of how cross-examination lengthwise has gone,
And direct.
But I imagine I'd be surprised if we get to or even get through Miss Roberts.
I hope we do. The repetitive nature of the setup and where people were sitting is just... Stop that.
I was only doing it with reference to this witness, Your Honor, because I think it's germane as to when he's looking out and where he's going and looking out.
Which is fine, but that was toward the end of your direct, the beginning of the direct. I think if you asked a question on who was there for the night, I think the jury has an answer at this point. So just try and cut it down now.
Absolutely.
Okay. So we are all set for tomorrow.
Just for prep purposes, because I'd like to use the afternoon wisely, do you have any idea who you might have on Tuesday?
I would love to know too, but I'm not asking Mr. Lally that. If he wants to tell you that, that's fine.
Okay, we can talk about it offline.
All right. We'll see you tomorrow.
Court, all rise.
Goodbye.